All right, we'll be starting in just a moment. All right, start at 15 seconds. And the attendance is going, so you're welcome to sign in. All right, everyone, please sign into the attendance. I've pasted the class notes here. Okay. Let's start off class today with a brief discussion of the midterm. The midterm will be on Wednesday. A few notes about the midterm. First off, it's self-administered. I've disabled the tracking software, which I am not a fan of. This is the stuff that sort of, monitors your movements and monitors your camera. I don't like that. There was actually an article in the Times about this the other day, which says it actually harms student performance when they think they're being watched. So putting aside privacy issues and other important stuff, it actually I think is counterproductive. The flip side of that is please don't cheat. If I find that people are cheating, I may have to reconsider my policy. Don't take advantage of my generosity. This is an ungraded midterm. It's for your own advantage. There's no reason for you to cheat. It's really stupid if you try. So please don't. I know when people cheat. It's an essay exam. I can see the patterns. I've done it before where I've seen people had very similar answers. And I investigated, and it turned out they had the same study group and they copied the same outline, so it was innocuous. But here it's going to be easier for me to pick this stuff out. The exam's open book. You can bring whatever you want. It will not help you. By this point, you should already have some semblance of an outline. I emailed you over the weekend. The way to prepare for my exam is not to look over your notes. That's meaningless. It's not to review your outline. That doesn't mean anything. It's actually take an old exam. So I'd encourage you before Wednesday, if you haven't already, to try to take 90 minutes and take an old exam. Now, because of the Zoom semester, we are not at the same pace as it was in past years. So if you look at an old midterm, there may be things that don't make sense, which is fine. Also, I change cases every year. So maybe there's some case I'm testing out that you haven't learned. That's fine. The goal is to sort of struggle and learn how these questions are posed. So please try and do this. Don't walk into the exam cold. You're really hurting yourself. Now, the modifications. I wish I can give you a full 90 minutes for the midterm. I can't afford it. We don't have enough time. In property, I can. It's not quite as hectic. So here's my compromise. I'll give you an hour. At 10:30, which is when our class begins, the exam will begin, right? I'm not going to proctor it. It's going to be automatic, right? So at 10:30, you begin the exam on your own time. And then you work for an hour, right? So from 10:30 to 11:30, you get to work, all right? At 11:30, I'll start Zoom up, and then we come to class. My goal is to go over the exam immediately, right? So you'll see exactly what you got right and what you got wrong. Now, it's not a full midterm. The full midterm will be 90 minutes. I can't give you 90 minutes. The full midterm would have 5 questions. I can't give you 5 questions. I'll give you 3 questions. So the midterm will have 3 questions, and you'll have an hour to do it, which is, I think, generous in time. It's actually a little bit more than you usually would have. So you should all be able to get your exam numbers on ExamSoft. If you don't know how, the registrar can help you with that. You should also be able to download the exam. I'm sorry it's not available yet. Things move a little more slowly when you're out in the building. You can't bother people to get stuff done, but it'll be done as quickly as possible. But definitely before Wednesday morning, download the exam. And once you download the exam, take it on your own pace, starting at 10:30. Now, the substance of the exam, okay? Okay? The substance of the exam is, Lainey asked if to download the software again. You know, I'm not sure. If you already have it, it might be good. It might be an update. I'm not sure. I don't know what version you have. Now, the substance of the exam is important. I usually ask two kinds of questions. One type of questions you're set in the present day, and the second type of questions you're set at some point in the past. I'll tell you, the midterm is always set in the past. It's always set in the past because I want to practice. I want you to get to practice on that experience. So you'll have a historical question tomorrow. What does that mean? It means that you are not going to be citing cases that happen after. If the case is in 1868, don't cite cases from the 1870s. Hasn't happened yet. There's also a word limit. Usually you have 1,000 words for 5 questions. I'm only giving you 3 questions, so you have 600 words. All right? Please read the instructions carefully. You have 600 words. Do not go over the word limit. I stopped reading at 600 words. I stopped reading. There's a word count feature in the software. It's under Tools. Do not use the character count. Every year someone uses character count and they write like 1,000 characters. That's like 4 text messages. Don't write 1,000 characters. People are laughing. One of you will do it. Don't laugh. It's not funny. 1,000 words. All right? So again, make sure you have your exam number. Make sure you have the software downloaded. Make sure you download the exam. It should be there by tomorrow. So, Michael, 600 words for the entire exam. 600 words for the entire exam. The instructions will be very clear. Okay. Questions on the midterm. Please take it seriously. Generally, the score someone gets in the midterm is their final exam score. There's movements up and down, but the curve curves. People say, I'm going to do better. I was like, okay, you go for it. But generally where you fall in the midterms, where you fall in the final. It happens, right? And I don't want to be fatalistic, but that happens every year. So if you've not taken this class seriously to this point, there's room for improvement, but it's very hard to course correct late in the semester. Think of like a battleship, right? You can't make sharp turns, right? If you start from the wrong trajectory, you're going to keep drifting off. I don't say that to scare you. I say that merely to state an obvious point. Where you are halfway this semester is probably where you'll be at the end. It's a myth that you can sort of just turn on the gas and turn on the afterburners and just catch up. You can't. People try, and sometimes people surprise me pleasantly. But there's a reason why you have a semester that's 28 classes over 14 weeks, because you need that much to get up to speed. The 3 or 4 days of the study period are not going to be enough to catch up. So I wish you all the best of luck. If you haven't already taken a sample exam, you're already behind the curve, because some of your classmates have. I know it's especially tough this semester with schedules, and I don't envy anyone in law school now. It's tough, but there are things you can do and things you didn't do, and then you're stuck with where you are. All right, questions? Whenever I say your midterm score is your final score, people start freaking out. It's true. I can give you statistics year after year. It happens. I wish it weren't true, but it's accurate. Especially in this class. And I think in property, there's more room for growth. In ConLaw, it's harder to catch up. Anything else? All right. This class, about presidential subpoenas, and the prior class about the Consumer Finance Protection Bureau are new cases. And I'll admit, it's always tough to teach a new case. And let me explain why. I learned from you. I know you don't believe that. I learned from you. A couple of you asked good questions, Moses and others. I learned from you. And then you say something and think, and I have to go back and start thinking it over and thinking it over and thinking it over and trying to refine it. It usually takes me about 3 or 4 years before you can actually teach a case that I'm really solid on it. It's not because I'm stupid or just I can't prepare well. Just it's hard to internalize this humongous case and distill it down in a way that makes sense for 70 people, right? I can keep it in my own head, but to make it accessible to an entire lecture class of 70 people is not easy. So I appreciate your really good comments and questions last week. It gave me some stuff to think about. And I'd like to begin class today by trying to clarify what seal of law did and did not hold. And I think that might give some clarity for you as well. And I'll admit, I don't even know that I'm right on these points. There are aspects of the Chief's opinion that I'm still not sure what he means. I'm still not positive. He just sort of writes in this fashion that it leaves things open. And we're sort of just grasping at these straws. What do you mean, John? What do you mean? Tell us. But he won't tell us. He doesn't like that stuff. All right, so let's take a look at some quiz questions. I hope will clarify the doctrine. All right, so let's look at question number 1. Multiple choice. Question number 1. Question number 1 is this. Congress creates for-cause tenure protection for a, quote, purely executive principal officer. What precedent should the court apply? U.S. v. Myers, Humphrey Executor, Morris v. Olson, seal of law versus CFPB. Okay. I think most of you have answered. Ooh, it's spread. Look at that. All right, who's next? Whoever's next, just please raise your hand.
I may.
Is that it? Benjamin, is that you?
Sorry.
All right, Benjamin. So let's just start off here and define some terms. What is a for-cause tenure protection? What does that mean?
Well, that means they have to be, if they're removed, it has to be for a certain set of reasons, malfeasance, ineffectiveness.
Very good. Can the president fire a person with these protections just because he doesn't like them?
No, it would have to fall into one of those categories.
Okay, so now we have our question here, Benjamin. Very good. Congress imposes for-cause tenure protections for a purely executive principal officer. What is our precedent? What is our case that we have to be citing here?
I'm sorry. Did you say the question again? I think I might have.
Question number 1, as written, right?
Right.
Congress creates for-cause tenure protections for a purely executive officer. What precedent is relevant here?
Would it be Myers?
Okay, why Myers?
We know that in Myers it established that the president could remove a purely executive officer, and in Humphreys it says the for cause is for the multi-member.
Okay, all right, very good. The answer here is A, Myers, which is about half of you got it right, but it was spread. Some of you put D, which is not entirely wrong, but it's not the best answer. It's definitely not B and C. One of the challenges with this class is knowing which case to apply. In your exam for Monday, you should discuss cases. You say the fact pattern here is similar to this case or different than that case, right? This is a relevant precedent to apply. When you do that, you show me you actually know the cases, right? You're not just giving me some blank rule from an outline that you bought somewhere, right? You need to understand how the facts are similar to these cases, right? When I write an exam, I try to take the fact pattern of a case you've read and I sort of twist it around. I flip it, I change things, and I make it that it's similar to a case, but not exactly. And you have to explain how the fact pattern shakes out with these precedents. All right, so the answer to number 1 is U.S. v. Myers. It's exactly right. Now, this holding is not very helpful because there aren't many purely executive officers, right? Generally, officers have some powers to make regulations, which are not exactly executive, and they have some powers to adjudicate, which is not exactly executive. All right, so let's take a look at question number 2, and I think Benjamin sort of gave the answer away, but we'll try this one. It's okay, Benjamin, you're fine. Congress creates for-cause tenure protections for the 5 members of the Federal Communications Commission. Which precedent should apply? And I think next up is going to be Lewis in about 10 seconds. Oh, and Tori, I'll get to can I get to you after the question? Okay. All right. I think most of you got an answer in. 5 more seconds. All right, Lewis, what is your answer here for number 2?
I put B, Humphrey's Executor.
Okay, why should B?
Because in Humphrey's Executor, that dealt with the 5-person panel of the Federal Trade Commission.
Good.
And it dealt with representatives that were quasi-legislative and quasi-judicial.
What the hell does that mean?
So they have the power to adjudicate some cases,
Good.
and they have the power to pass regulations, which falls under a legislative aspect.
Okay, very good. So just to close the circle, Lewis, is the commissioner of the Federal Trade Commission purely executive?
No, they're not purely executive.
Okay, good. Thank you so much, Lewis. All right, so the answer to number 2 is B. And almost all of you got that one right. That's very good. Okay. So again, you have Humphreys and Myers. Myers held purely executive, you cannot have for-cause protections. But for these quasi-legislative, quasi-judicial executive officers, you can have for-cause protections. Okay, let's try question number 3. Congress creates for-cause tenure protection for the Deputy Secretary of State who was appointed by the Secretary of State. Which precedent should the court apply? Yeah, this will be for Chris in about 10 seconds. Chris, you here? Chris? Nope. Dina, you here?
Yes.
All right, Dina. So let's just start off. How would you characterize the Deputy Secretary of State in this case?
As an inferior officer.
Okay. How do you know they're inferior?
They are appointed by the Secretary of State, not by the President.
Ah, and what would we call the Secretary of State? What kind of officer is he?
Principal officer.
Ah, very good. So, Dina's right. In this case, we have the Secretary of State appointing the Deputy Secretary of State. The Secretary of State is a principal officer, and the Deputy Secretary of State is an inferior officer. How do we know this? Because an inferior officer is appointed by the agency head, right? He does not get appointed by the president. He's not confirmed by the Senate. All right, Dina, so now let's go to the next step. Congress creates for-cause tenure protections for this inferior officer. Is Myers relevant?
No,
Why?
because Myers was for principal officers.
Okay, purely executive principal officers. Very good. Is Humphrey's Executor relevant?
No, because that was for multi-member boards.
Okay, very good. So what's the answer here?
The answer is Morrison.
Okay, good. And just remind us, Dina, what was the officer in Morrison? What were the facts in that case?
Morrison was the independent investigator for the
Very good. No, very good. Yeah, she's independent counsel. Very good. Okay, very good. Thank you so much, Dina. All right, so Morrison is a relevant precedent here, right? We're not dealing with a purely executive official, right? We're not dealing with a what do you call it? This 5-member board. The closest case here is Morrison, right? Now, Morrison wasn't limited to inferior officers, although I think that's how the court read it in seal of law. All right. Now let's go to the last question. I know by process of elimination you should all get this one correct, but I'll I'm not stupid, but I'll put it up here anyway. Keep getting better with each one. Yeah, man, that wasn't quick. Congress creates for-cause tenure protection for the single director of the Federal Housing Fairness Administration, who can issue regulations and adjudicate disputes. Which precedent should apply? Myers, Humphreys, Morrison, or seal of law? And this will be for Harrison in about 10 seconds. You guys, this was too easy. All right. I'll stop it there. All right, Harrison, what's your answer here?
See the law.
Yeah, you got the easiest one, right?
Yeah.
In the new version of Zoom, you can actually spotlight 2 people at once. Notice that? Both spotlighted. Yeah, I just updated my version between classes. I'm very happy with that. All right, so 100% of you got this one right, which is good by process of elimination. If you got this one wrong, you're not paying attention. But let's dive into this a bit, Harrison. How do you square this one, Harrison, with Humphrey's Executor? I thought issuing regulations is quasi-legislative. I thought that adjudicating disputes was quasi-judicial. This is a principal officer. Why wouldn't this case be governed by Humphreys?
Because it's a single officer versus a panel.
But was Humphreys limited to only multi-member panels? Was that the holding in Humphreys that if you're a multi-member panel and only a multi-member panel to get this rule?
Yes, with your multi-member body, you can remove 4 cause.
No. Just be very... My question's a little different. I agree. Humphreys involved a 5-member panel, right?
Mm-hmm.
But was the holding in Humphreys limited that you could only have tenure protections for multi-member boards?
No, I guess not. I think he was addressing that specifically. But
So where did the restriction come from that Humphreys had such a limitation? Where did that rule come from?
is that
What case created that restriction?
Morrison?
No. What case did we just study?
Oh, so Sela did.
Sela.
Yeah.
What does Sela law hold? What was the whole thing in that case?
The for cause protection is invalid because it's a single officer and not a multi-member body.
Even though it's quasi-legislative and quasi-judicial?
Yes.
Okay, very good. All right, that's right. Thank you, Harrison. All right, does everyone see those 4 questions? I think when you put them in sequence one after the other, this topic makes a little bit more sense, or maybe not, I don't know. And let me try and summarize this a bit. And again, what I'm saying here, I don't know if it's necessarily correct, because the Chief Justice doesn't always write for clarity. He writes for obscurity. When he wants to be clear, he's clear as day. No one's better on the court than him. But when he wants to be obscure, he can be quite obscure. It pisses me off because I have to teach it. But this is the world we're living in. We're not, it's new stuff. So I think you have 4 different precedents that govern the removal of power. Right? So first, if you have a purely executive principal officer, you follow Myers. Right? In this first category, for-cause tenure protections are unconstitutional. The president has an absolute power to remove purely executive officers. That's the easy one. But I'm going to tell you, there are not many purely executive officers. They usually have mixed powers. In the second category, we have these sort of quasi-legislative and quasi-judicial principal officers and multi-member boards. So when you have both, it's quasi-legislative and quasi-judicial, and it's multi-member board, you follow Humphrey Executor. And in the third case, you have inferior officers with tenure protections. Morrison v. Olson's the precedent here. Now again, Morrison involved an inferior officer, but I don't think that was the holding. I think the chief limited Morrison to inferior officers. So I think the chief rewrote Humphreys, and I think the chief rewrote Morrison. But then we get to the more recent case. What if you have a single member who is quasi-legislative, quasi-judicial? We do not follow Humphreys. We follow Sela law. And what does Sela law follow? Sela law says there are no limits. You cannot have these 4 tenure protections. Right? You cannot have for-cause protections for a single director, even if he has quasi-judicial, quasi-legislative powers. So I actually think the chief, in the end, put together somewhat of a coherent framework. He just wasn't so, how do I say it, clear about what he was doing and why he was doing it. But in the end, I think these 4 categories make sense. If it's purely executive, Myers. If it's a 5-member board, Humphreys. If it's an inferior officer, Morrison. If it's a single director, Sela. Right? I mean, it's actually, once you get to the end, it's clear as day. But getting there is just he did it in a very obtuse fashion, because Roberts does not like saying, I'm overruling a 90-year-old precedent. I'm overruling an 80-year-old precedent. Okay. I'm going to shut up now. Tori, then Lewis?
Yeah, I just had a quick question about number 1. I understand the purely principal officer thing, but isn't it that they don't have for-cause protections? Wasn't for-cause protections created in Humphreys?
No. In Myers, the postmaster had for-cause protection.
Okay.
Yeah, that was why Myers arose, because Congress made it that the president couldn't fire the postmaster. There were restrictions, right? To be precise, it wasn't for-cause protection, but there were limits on the president's power to remove the postmaster. And Chief Justice Taft said you cannot have any limits.
Okay, all right, thank you.
Lewis, go ahead.
For Humphrey Executor, it doesn't have to just be a 5-person panel. Could it be like 3 or 7? Just depending. Is it just multiple members?
You know, I don't know if there's in our government we have a 7-member panel or 3. I think it's almost always 5. I can't think of any. It's almost always 5, and the reason why is 3 of the way it works is 3 members of the president's party and 2 members of the minority party. So it's always staggered 3 to 2. You know, I don't know if there are any 7-member. I can't think of any. Okay, thank you. James, go ahead.
So they quote Perkins, which I just looked up as like 1886
Don't-
for the same idea.
Yeah, no, he's lying. Don't worry about Perkins. I'm sorry, I shouldn't say that. It's an old case that really doesn't say what Robert says it says, and don't worry more about than that. Robert likes citing old precedents even if they're not relevant, because it looks old and it's not him making it up. Yeah, Robert's really had to struggle with this opinion to make it cohere. In the end, I think it coheres quite well. In fact, I think he actually brought some clarity to this area. Just I don't like the way he did it. Lainey, go ahead.
If he struggles so much to get to the opinion, is that because it's not right and it's just the answer he wants for the president or whoever he's trying to please?
Oh boy. So I think the chief has an aversion to reversing precedent. He at all costs wants to be seen that he's following precedent. But he doesn't like those precedents. So how does he follow precedents he doesn't like? He pretends. Like make-believe, right? He says, well, we're following these precedents, but he reads them in a way that's inconsistent with how they were written. And in my book, not the book I wrote, but in my opinion, there's a problem when you basically quietly overrule precedents because you're not saying out loud. Anyone who reads it carefully knows what you're doing, but to the public at large, it looks like, oh, we're just keeping things the way they are. So Roberts consistently rewrites precedent. Now, I think one of the best aspects of our future is he's no longer the swing vote. I'm actually thrilled about that. One way or another, he's not the swing vote anymore, so his opinion matters much less. He drives me nuts. Teaching them is just a very tough cases to teach. There's a question in the chat. If I give you an exam question that was set before 2020, which is basically last year, you don't have seal of law. And before seal of law, it wasn't clear that a single member director was unconstitutional before cause. In fact, several courts held that the CFPB was valid under Humphrey's Executor. I said again, before the Supreme Court ruled in seal of law, the lower courts upheld the Consumer Finance Protection Bureau. They said this is fine under Humphrey's. The Kagan opinion, I think, was probably correct before seal of law, but the chief changed course, which is fine. I don't have a problem with the court changing direction. They should just acknowledge why they're doing it and don't try to hide it under some old, 70-year-old case. All right. Questions, my friends, on this. James asked, would we look to CFPB and evaluate his role? I'm not sure what you mean, James.
Like from Myers.
Oh, you're asking whether it's purely executive or purely...
Well, wouldn't we evaluate his, if it's before 2020, wouldn't we evaluate that person's role and what his duties were?
Right. And in this case, he's quasi-legislative and quasi-judicial. Right? Because he makes rules and he can adjudicate disputes. So if you follow that approach, he'll be fine in Humphrey's Executor. Right? What Roberts held that was new in seal of law is that if it's single member, it has to be at will. It cannot be for cause protection. Thank you. Make sense? Lainey, go ahead.
Do we get to a point in this course where we talk about one of the cases referred to all these agencies as like a fourth branch of the government?
Yeah.
And I can tell you from personal business experience, CFPB is a disaster. So I don't think my experience with it and why it's a really, really bad, too big agency applies to any of the cases we're doing, but at some point, do we get to that?
Sure. Yeah, we. What is an administrative agency? We don't quite know what branch it fits in. It's Justice Jackson called this sort of headless fourth branch of government. It's a part of our system of government now. It's not going anywhere. The CFPB is in some quarters popular and in some quarters very unpopular. Depends which perspective you're coming from. For some consumers, it's been great, and for regulated businesses, it's been a disaster. Right, so it depends, which angle you're looking at it from. But the validity of these agencies is, I think, more or less settled. Even in the end, when the court found that the structure of the CFPB was valid, the remedy was actually quite narrow. The remedy was just, okay, now the president can fire the director for any reason at all. The court just removed the protections. The plaintiffs wanted to kill the entire agency, which wasn't going to happen. This is now almost a 10-year-old agency. They weren't going to destroy it. Okay. Moses asks in the chat, isn't the Chief Justice's rationale, I am following precedent? Well, that's what he says. He always says I'm following precedent. But he has this funny way of not actually following the precedent. Justice Thomas, Moses says, has a solution. And that solution is you overrule the precedent. And, there's a virtue to the Thomas position, which is, let's not pretend we're doing something when we're not actually doing it, right? Let's not pretend we're sticking with a 70-year-old precedent. Let's just start from scratch. And James says, cite yourself repeatedly. Yes, Justice Thomas likes citing himself because he's the one who says it, right? He can't cite anyone else. He cites himself. That's the... what a string cite is, right? Where you kind of have several citations in a row. You can have a Thomas string cite that's like 8 levels deep, just, the entire doctrine in the world of Thomas. By the way, happy Monday, everyone. Today's the first Monday in October. Today's the start of the Supreme Court's term. Right now, the Supreme Court, we have just finished their arguments. They're live streaming on C-SPAN because of the COVID pandemic, but I am here with all of you and not listening to the arguments. I will listen to them. I'll listen to them later. Today, the cases, there was actually one case that might sound boring, but it's very important. It's a water dispute between Texas and New Mexico on the Pecos River out west. These are actually very important cases involving water rights in Texas, which I have not had time to read. The other case, it's sort of a strange case where Delaware requires their judges to have a mix of both Republican and Democrats. They're actually having to be they have to have a certain balance in the court system. And whether that's unconstitutional to require judges to have these party affiliations. It's kind of a weird First Amendment case, which I haven't followed too closely. But happy Monday, first Monday in October by statute when the court's term starts. What fresh hell they'll bring me this semester, I cannot tell you. As hard it is to teach the subpoena cases and to teach the CFPB cases, I dread what comes next. And I can't keep track of 11 justices, 15 justices, who the hell knows? We'll have 1 million justices in the court. All of you will be justices. We'll have, like Hollywood Square Zoom style, like 49 grid with all the justices in the court. It will be lovely. It'll be hard to make these. Imagine creating an outline when there are 11 justices in the court. That's going to be even harder. How much more reading you have to do? Students can court packing. Okay. Any questions on seal of law? We're still going to 40 minutes to discuss. All right. I'd like to now move on to today's topic, which is the issue of presidential subpoenas. And again, these are new cases. They're not even, 3 months old, 4 months old now. And they haven't quite settled. In fact, they're still pending. I always hesitate to assign new cases. Maybe I shouldn't. I don't know. But I think it's important that you're somewhat up to date. Most of the cases you study are somewhat obscure and old. This one's kind of live and timely. There are 2 cases we have today, both involving President Trump. The first one's called Trump versus Vance. Cyrus Vance is the district attorney for Manhattan in New York County. And the second case is Trump versus Mazars. You may have never heard of Mazars. It's an accounting firm. It's an accounting firm. Okay, so what is at issue in these cases? As I'm sure you know, there's a tradition going back at least to the 70s in which presidents released their tax returns and financial records before coming into office. And the thinking was the tax return is a very effective way of figuring out what are a president's financial interests. You know, where is he gaining money? Where is he losing money? But also it's a way of sniffing out conflicts of interest. Right? If a president has certain obligations, that may shade his ability to do his job. So, you know, if the president has a huge debt, maybe he'll favor legislation that would forgive debt. Kind of a strange example, but it's entirely possible. If the president invests in a certain industry, he may favor legislation that supports that industry. If the president disfavors some industry, he may support legislation that opposes it. And of course, foreign policy issues. If the president has certain, let's say, foreign entanglements, that may impact how the president conducts foreign policy. I'll leave it there. President Trump did not release his tax returns, and that became a huge political issue in 2016. Just not even a week ago, feels like a year ago, but not even a week ago, the New York Times somehow got a hold of President Trump's tax returns, and they didn't publish returns, they published information about them. I really don't care to talk about it. It's not very important. No one even cares anymore. But this was really important a few months ago. You know, the end of the world, the tax returns, right? Very, very, very important, right? One thing the last 4 years have taught me is that nothing is as important as you think it is, right? Things that seem really important fade very quickly. So, for example, impeachment. When I was teaching this class last semester, we had an impeachment trial. Does anyone even... When was the last time anyone even thought about the impeachment? It's just like, that happened? It was an impeachment? Yeah, it's like 6 months ago. Or 8 months ago. So nothing's ever as important as you think it is. That's just what I've learned. People have short attention spans and we move on. But for a period, this was very important. In 2018, there were two efforts made to try to obtain President Trump's financial records. Okay? The first case, the Vance case, came from the New York City District Attorney. The second case, Mazars, came from committees on the House of Representatives. Now, they had different rationales of why they requested these documents. Okay? Who am I up to? Morgan, are you next?
Yes, I am.
Okay, thank you, Morgan. Morgan, let's start with the Vance case. I'll come back to Mazars later. Morgan, why did the New York District Attorney issue a subpoena? By the way, a subpoena just means a request for a document, right? A subpoena is requesting a document. Morgan, why did the New York District Attorney issue a subpoena on Trump's financial firms?
Because they were trying to, they were doing an open investigation on business transactions that involved individuals who violated state law, and so they wanted to get Trump's business information and taxes and all that good stuff to help with fraud and investigation and just...
What were they investigating?
his tax return.
No, I know they needed the tax returns for the investigation, but what was the district attorney investigating? Did they say?
No, I don't remember in Vance, but
Nope.
I remember reading about it.
We'll get to the other one in a minute. Morgan, did the district attorney say why he needed the tax returns?
I don't think so.
That's strange. Jose, you here? You here, Jose?
Yes, sir. Yes, sir.
Oh man, you sound like you're a robot. Do you have a different mic you can maybe use? You there? You sound like Stephen Hawking. All right, we will try this. Jose, still there?
I'm still here. I don't know if you can hear me.
Oh man, this is really hard. I'm sorry. I'm going to pass you. It's not your fault, but just maybe check your microphone. You sound like robotic. It's very staticky. It's going to be too hard to hear. I'm sorry. Moses, you here?
Yes.
Okay, Moses. Let me ask you a question, please. Yeah, Jose, don't worry about it. Just I don't want. It just was really tough to make you out. So, in what context, Moses, was this subpoena issue? Just give me the background of how this came about.
So I don't know what you're asking, but I'm going to try to figure out. So actually,
That's good.
So the New York District Attorney is going to actually issue the subpoena to Mazars, the accounting firm.
Good.
So he doesn't issue it actually to President Trump. He just actually issues it to
Good.
accounting firm.
Good.
At this part, I'm a little fishy. So I'm just going to summarize what I think happened afterwards.
No, we'll get to the after in a minute, but I want to say that before.
But no, what I'm saying right in the middle of it, so I'm thinking is that because tax returns are essentially the president's tax returns.
You're right. You're answering question like 3 down the road. I want to go a little bit earlier, okay?
Okay.
Was the district attorney acting on his own behalf here?
No, he wasn't acting on his behalf. He's acting on the part of the state.
Well, who actually issued the subpoena? Who actually requested the documents?
Now that's a good question.
Yeah.
Well, the office acting on behalf of the grand jury.
The grand jury. Okay, Moses, where I'm going with this. Do you know what a grand jury is?
Yes, they are a secretive panel that basically chooses to, they look at evidence and say, does the prosecutor have enough evidence to show probable cause?
Oh, that's really good. But you said a word that I think is very important. Secretive. Wait a minute. We have secret panels requesting. Doesn't sound very sketchy. How do we have a secret panel requesting stuff? Is that all right? We do that?
Well, yes, no, sure, yes, no. That's a great question.
Okay, I think okay, good enough. Thank you. I think your yes, no, maybe is a good answer as well. All right, so let me just give some background. Most people know what a jury is, right? A jury, usually 12 people, decides a case. It might be a criminal case, in which case you need a unanimous jury for conviction. It might be a civil case, in which case you might need a majority of the jurors to vote in a specific way. But a jury is a common feature of our legal system. Now, you don't really know the real name of the jury. It's actually called a petite jury. P-E-T-I-T. Or is it P-E-T-I-T-E? I can never remember. Right, it's French. A petite jury is what's called small, right? Petite means small. A petite jury is only about 12 people, right? They decide cases. But there's another kind of jury in our legal system called a grand jury, a big jury. right? The petite jury comes into play after a person is formally charged with a crime, right? That's a criminal trial. But when the district attorney is investigating a crime, he relies on what's called a grand jury. A grand jury is, as Moses said, secretive. He's right about that. A grand jury's job is to investigate. The reason why grand juries are secretive is you don't want people to be falsely accused. For example, let's say the district attorney accuses someone of a crime, and the grand jury says, no. He didn't do that. That's just ridiculous. There's no need for a trial here. It would be very bad if that information leaked out. Because even though the person was never tried and given a chance to defend himself, he was merely accused. So the entire process of accusing someone of a crime at the outset is filtered through a grand jury. Right? Again, the purpose of the grand jury is to investigate. And this is a group of people, might be 30 or 40 jurors. They have to decide a very simple question. Moses, I think, phrased it well. Is there probable cause, right? Is there enough to go on here? Should this case proceed to a trial? Should this case proceed to a jury, right? This is before the charge is even publicized, right? Is there enough here to go forward? Now, the grand jury isn't sitting there by themselves in a room just talking. They're having some guidance. The district attorney helps them and guides them and says, well, here are the facts and here's the law. What do you think? Is there enough to go forward? Now, there's no judge in a grand jury proceeding. It's just the prosecutor and the grand jurors. In some cases, the defendant can speak to the grand jury, but that's rare. Now, when the grand jury is investigating, they may say, you know what? We need some more information. Right? We can't make our decision based on this limited record. We want testimony. Right? We want some witness to testify what they saw. So the grand jury can issue a subpoena to require a witness to testify before the grand jury. They can do that. The grand jury might also want some documents. They can issue a subpoena for a document and say, you know what? In order to decide whether to charge this person with a crime, we need to look at some records, financial records. And that's what happened in Mazars. I'm sorry, that's what happened in the first case, Vance. The New York District Attorney convened a grand jury. The grand jury was conducting an investigation into what we don't know. To this day, we're not really even sure what they're investigating. Now, we know. They're investigating Trump fraud and Trump tax fraud. It's not that hard to figure out what they're investigating, but they haven't publicly said it. It's all this sort of, insinuation, innuendo, right? Or wink, wink, nod, nod. But we all know what they're looking for. They're looking for tax fraud. That's why they want these records. That the president hasn't paid his taxes, that he's lied on disclosures, etc. Not important for this class. But in this case, the grand jury wanted the president's financial records. And a lot, like a decade of records. We're talking a lot of paperwork. And the grand jury said, in order for us to do our job, we need this evidence. Right? We can't decide on whether any criminal conduct has occurred unless we look at these records. Now, we all be candid here, right? This was the New York District Attorney's request. It came from the grand jury, but Cyrus Vance, the District Attorney, wants these things. He wants to prosecute the president. It's pretty, pretty freaking obvious here why this is happening. This is not some sort of just, they're just looking around. They want to see if there's stuff they can charge the president with. That's what the grand jury does. All right. So the District Attorney, by acting on behalf of the grand jury, issues a subpoena to the accounting firm. They say, we want a decade of Trump's tax records. Please give it to us. The accounting firm's like, we do not want to get involved, right? This is not our fight. We have these documents. We don't care, right? We will do whatever the court tells us, right? The accounting firm does not want to get involved. So what happens? Trump sues the district attorney. And he argues that the subpoena itself is unconstitutional. Right? So this case did not arise from the state court grand jury proceeding. It's actually a secondary path where the president sued the district attorney to what we say quash. Quash is like squash. It's to try and kill the subpoena. It's Quash. It's like squash without an S. I don't know the origin. But to quash a subpoena. And then Trump argued that the subpoena itself was unconstitutional. Huh. Erica, you here?
Yes.
Erica, thank you. What was the president's argument for why the grand jury subpoena was unconstitutional?
He said that he had absolute immunity from the criminal process, and especially because it's coming from the state, not a federal.
Okay, so you're right. I'll come back to the absolute immunity point in a second, Erica. But this subpoena wasn't to President Trump. It was to his accounting firm. How can the president assert immunity if the subpoena is not even directed at him?
It's his personal information.
So did the court think it mattered that this was to an accounting firm rather than the president directly?
No.
Yeah, you're right. The court didn't seem to care. Now, a lot of people thought this was absurd. How could the president raise an immunity defense on behalf of papers he doesn't even have, right? These are papers as his accounting firm has. But the courts and our beloved John Roberts just sort of, he didn't get dwell on that one for too long. But Eric, you said something else I think is more important. You said that the president asserted absolute immunity from the subpoena. What does that mean, absolute immunity from the subpoena? What does that phrase mean?
Absolute immunity. I mean that they can't really come after him because he's such a high position.
Okay, let me just ask you one follow-up. Does anyone else in this country have an absolute immunity from a subpoena?
Don't some judges and other officers?
Well, immunity from suit or subpoena?
From suit.
Oh. So was the thing the president was asking for, does anyone actually have that? Anyone else?
I don't believe so.
No? Okay. So thank you so much, Erica. Very good. All right. So the president argued that he had what might be called an absolute immunity from a subpoena. Right? And just be clear, this is a criminal subpoena. And the type of subpoena matters when we get to the second case, which comes out differently. But the president argued that he has absolute immunity from a subpoena. Now, Jeffrey, here?
Yeah.
So, Jeffrey, I always ask a question. I say, what is the source of some authority, right? What are the two possible sources of presidential immunity? Where could they possibly come from? Any presidential power, what are the two possible sources?
Well, the what is it? The executive power clause, not the executive power clause, but they have absolute executive power. I forget the name of the clause.
Help me out here. Just more generally, what are the two possible sources of presidential power? The two basic sources.
Article 2.
Well, you have the Constitution. And what's the other possible source?
The courts.
No. Think of Youngstown. What are the two possible sources of presidential power? Think of Jackson.
Oh, is it congressional approval? Or?
Congress. Very good. So in this case, Jeffrey, has Congress given the president an absolute immunity from subpoenas?
No.
No. Does the Constitution give the president an immunity from a criminal subpoena?
It doesn't really say anything on the subject.
It doesn't really say anything on the subject. You gotta give me a little bit more.
It doesn't explicitly say that he's absolutely immune.
So where did Trump get his argument from? What's the argument that the president is immune from subpoenas? President had some argument. What argument did he make?
Well, they brought up past cases.
But what were those cases based on? What text do we have?
I'm confused.
Yeah, me too. What's the basis? What would the basis in the Constitution be for immunity from subpoenas? What would the basis possibly be?
The take care clause, or separation of power, right?
Is there a separation of powers clause? I'm asking for text here. Is there any text?
No, not really.
No. Yeah. Thank you, Jeffrey. Yeah, you got where I was trying to get at.
Right. That's what I was so confusing. There is no text.
Yeah. No, I think your struggles are appreciated, right? There is no immunity clause in the Constitution. Right? There's no express clause in the Constitution that says the president's immune. It doesn't exist. But there are some cases in which the court has held that there might be some immunity. Right? So, for example, you have the case of the United States against Nixon. We talked about this case a little bit in our context of Morrison v. Olson. But the long and short of that case is that President Nixon received a subpoena in a criminal case where the defendants, as well as the prosecutor, wanted recordings from the White House. Right? They wanted the secret tapes from the White House. Nixon said, I have an absolute privilege. I don't have to turn over the tapes. Okay? Now again, that was a subpoena during a criminal trial. And the Supreme Court said, no, you do not have an absolute immunity. In a criminal trial, you must turn over the tapes. But there was an exception. The court said if there's some sort of national security implications or some sort of really important reason why the information should not be disclosed, the president can withhold it. But that wasn't an issue in this case, right? This is all domestic stuff. But the Nixon case only concerned a subpoena during a criminal trial. Okay? Kevin, you here?
Yes, Professor.
Kevin, the Nixon case concerned a subpoena during a criminal trial. Was there a criminal trial at issue in the Vance case?
No.
No. When did the subpoena... When was the subpoena issued?
It was during the grand jury process of the investigation.
Exactly. So was this case governed by the Nixon case? Was it dictated? Was the result dictated?
No.
Okay. So Kevin, let me ask you a follow-up. What's another huge difference between the Nixon case and Vance? There's a huge difference. Okay, so one is Nixon arose during the trial and Vance arose during the investigatory stage with grand jury. What's another huge difference, Kevin?
Is it that, I don't know if I'm getting ahead, but I know one issue that was brought up quite a bit was that most of the precedent was about federal cases.
Oh.
This was arising from a state issue.
Why does it matter that Nixon subpoena came from a federal officer and Vance comes from a state officer? Why should that make a difference?
Could it be a supremacy clause
question.
Oh, good. Give me more. What do you mean supremacy clause violation?
So the federal, I'm not going to get the wording exactly right, but when there's a conflict, the federal law trumps, so the federal government is the supreme law. So a state, I guess a state official like a DA taking it upon himself to attack the executive branch, or if that's what it's perceived doing, would maybe be the issue.
Very good, Kevin. You've done great so far. I want to give you one more question, if you can. What case have we studied in which the state government attempted to regulate a federal entity? What case? Was it very early in the semester?
Yeah, the bank, McCulloch, Maryland.
Ah, perfect. Okay, very good, Kevin. You got exactly what I wanted. Okay. So one of the first cases we studied this semester, excuse me, was McCulloch, Maryland. And you recall that in McCulloch, Maryland, the state of Maryland put a tax on the federal bank. And the Chief Justice, John Marshall, famously wrote that the power to tax is the power to destroy, right? That you cannot have a state institution destroying a federal institution. That was a very early precedent from the court in the 1820s. So President Trump argues in this case that, well, there's a difference between a federal subpoena to the president and a state subpoena to a president. Trump also argued there's a difference between a subpoena during a criminal trial and a subpoena during a mere investigation. Sierra, are you here?
Yeah, I'm here.
Does the court find that those distinctions matter?
No, they didn't.
No, they did not. Why not?
Does it have to go back to the case involving Burr?
Yeah, let's look at Burr for a minute. Yeah, let's look at. Tell me about Burr for a bit.
Yeah, so Burr was on trial for treason. I guess that General Wilkinson, he wrote a letter to President Jefferson accusing Burr of plotting to attack New Orleans and revolutionize the Louisiana Territory.
Mm-hmm. Good.
And then President Jefferson submitted that letter along with other materials to Congress, and they brought up charges against Burr.
Okay. So according to John Marshall, right, Jefferson complied with the subpoena, so Trump should as well. Is that the lesson?
Yeah, because I think following Burr, there a lot of presidents, when they were issued a subpoena, they followed the subpoena. So.
Okay, very good, Sierra. Now, what if I were to tell you that John Roberts got this wrong? No, you wouldn't believe me, would you? So let me give you some background. Before this case was even decided, I wrote this long article on the Burr trial, which I've been sitting on for some time, and I didn't know what to do with it. But then when Roberts wrote this opinion, I basically said, I'm going to publish it now. Here's what actually happened. There was a lengthy criminal trial involving Aaron Burr. If you saw the Hamilton musical, Aaron Burr is the person who shot Hamilton. Aaron Burr is also the person who became the vice president under Jefferson. Burr was a very strange figure. After he left the vice presidency, he got into some mischief. Exactly what he was... we always find a way to talk about Hamilton. Burr got into some mischief. He started to cause some trouble out west on the frontier. Exactly what he was doing still isn't clear. But General Wilkinson accused Burr of treason. The irony is that General Wilkinson was a traitor. He was actually on the Spanish payroll, right? So Wilkinson was a spy for the Spanish, but then he accused Burr of being a spy for the French or the Spanish. The allegations are very vague, and it's not really even clear what was going on. Jefferson flipped out and said we need to charge Burr with treason. The case was brought and filed in Richmond Federal Court. Who presided over that proceeding? None other than John Marshall, the great Chief Justice. This trial stretched over the summer. It took several months to go through. And at various points, Aaron Burr requested a subpoena to be issued against President Jefferson. He wanted the letter that General Wilkinson had sent to Jefferson, the original. Jefferson said, no thank you. I will give you a copy of the letter with parts redacted as parts were cut out. Now, when a court orders you to submit the original document, you submit the original document. You don't give a copy, right? This is not like, you scan it, you make a Xerox. A copy meant by hand, right? And there was no guarantee the copy was accurate. Right, so basically, I'm summarizing a very lengthy proceeding. Marshall said to Jefferson, turn over the original document. Jefferson said, nope, not going to do it. Here's a copy for you. Did Jefferson comply with the subpoena? Not really. He voluntarily provided a copy of the document. So both Marshall and Jefferson sort of negotiated a truce, right, where they didn't actually surrender their power, but they didn't really assert their power either.
Hey, Professor, I'm sorry to interrupt. Could you go back about a minute because you cut out completely, and I think for everybody.
A minute? Oh, God. A full minute?
Marshall said to Jefferson to turn over the papers.
Oh, so good, too. Okay, fine.
I'm sorry.
No, that's okay. I apologize. Zoom University means I get to repeat myself. All right, so...
He didn't comply.
Yeah. Marshall ordered Jefferson to turn over the papers. Jefferson did not turn over the papers. He turned over a copy of the papers, right? And again, a copy is by hand. It's not a Xerox. It's not a scan. So there's no guarantee this was authentic. Did Jefferson comply with the subpoena? Not really. He didn't. Both Marshall and Jefferson found a way to avoid dispute and not fight each other publicly. They still didn't give Burr what he wanted. In Vance, John Roberts tells a sanitized version of this account where the great Chief Justice issues a subpoena and President Jefferson dutifully complies. Give me a break. If you're noticing a pattern, this is why I'm such an anti-Roberts fan. He makes stuff up. He shades precedent. He rewrites precedent in a way that's most conducive to him. And he does without acknowledging it, which is why it drives me bonkers. If he would just say the record here is ambiguous, but this is the correct ruling, I wouldn't care so much. But he consistently pretends things are the way they are not. And it just drives me nuts. Again, I don't mind moderation. Moderation's fine. But don't make stuff up, because then I have to go correct it to my students. It's a lot of extra work. And my Zoom freezes, and I'm doing the robot walk, right? It's very problematic. Laney writes, Jefferson wanted Burr to be guilty. Oh, yeah. If you think the president can't direct the prosecution, go look at this case. It's fascinating. Jefferson was writing letters to prosecutors saying, go after him, go harder, go charge him with something else. In fact, at one point, this is actually funny, Jefferson told the prosecutor to criticize Marbury versus Madison because it was wrong. He said, you go tell John Marshall Marbury was wrong. Can you imagine? These guys hated each other. Whatever hate there is between the court and the president today was nothing compared to Jefferson and Marshall. Anyway, but Marshall creates this precedent, so to speak, which wasn't really there, that the president can comply with the subpoena. Other presidents followed subpoenas, but it isn't clear that they were following them because they were required to, right? This sounds very silly, but it matters. If someone issues a subpoena to the president says, you know what? I am not following the subpoena, but I'll give you the document anyway. It's voluntary. Do you see a difference? Say, well, you don't need to subpoena me. Here's the document voluntarily because I'm a nice guy. So there was not a clear instance where a court actually enforced a subpoena. Right? Presidents voluntarily complied. Jefferson voluntarily complied, as did the other presidents. But in this case, the president was not voluntarily complying. He was trying to fight it at every turn. But in the end, in the Vance case, the court held that the president is not above the subpoena power. That even a state grand jury has the power to request this information. And there's no absolute immunity. The president can still assert a defense, saying that this is harassing, this is a fishing expedition, this is too far, but there's no absolute privilege. Indeed, as we speak right now, the federal court in New York, the Second Court of Appeals, is deciding whether to permit this case to go forward. It ain't over. There's still a slight chance that in the next 30 days or so, the Supreme Court's asked to decide whether to block the release of the tax returns right on the eve of the election. This stuff never ends. But at a minimum, this case held that there's no absolute immunity from a state grand jury subpoena during a criminal investigation. Okay. Questions on the Roberts majority. Oh, I can't wait till he's not the swing vote anymore. It's going to be excellent. We'll have Kavanaugh Gorsuch as a swing vote, which we're going to hate for other reasons, but it won't be Roberts. Okay. He had a really short run of the swing vote, barely 2 years. He was, before Justice Ginsburg passed, Roberts was at his peak. And he plummeted quick. All right. We have a dissent from Justice Thomas. Justice Thomas would have said there's absolute immunity. He also screwed up the Marshall precedent. The Burr precedent. I don't think Thomas got it right either. So look, they all use the sanitized version where John Roberts is God and Jefferson is his serf, and it's not the case. There's a lot more nuance to that history. Justice Alito also dissented. He seemed worried that the purpose of this investigation is not to actually investigate criminal activity, but to embarrass the president. And by giving the state prosecutors power, they can cripple the presidency. Keep in mind, federal prosecutors work for the president, so in theory, the president can keep them in line. But state prosecutors are elected in partisan elections. And you're allowing a state official to basically cripple the presidency. A couple years ago, I had an exam question based on this issue. What happens if a state judge orders an arrest warrant for the president? Right? A state judge issues an arrest warrant for the president. And a state police officer goes to the White House, or I guess Walter Reed, and knocks on the door and says, "You're under arrest, Mr. President." And the Secret Service says, "Yeah, you in what army?" Okay, let's say the president gets bail. And let's say the judge requires the president to be present in the courtroom during his criminal trial. The president says, "Sorry, I need to go, give the State of the Union address." Right? Would it even be possible to exercise criminal process against the president? The court doesn't go there. All they say is that subpoena can be issued. The court also didn't decide whether the president can be indicted, whether a sitting president can be indicted by a state grand jury. Gavin, go ahead.
And your little hypothetical there with the police officer walking up to the White House with the arrest warrant, isn't that police officer part of the executive branch?
Not the New York State Police Department.
Okay. In the state.
Yeah, the New York State police officer walks up, New York State trooper walks up to the White House and goes, knock, 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 I'm here to arrest the president. Yeah.
That makes more sense then.
Yeah, you and what army? But that illustrates why this case was perhaps considered so risky, right? By allowing the state prosecutor to subpoena the president, you're setting up the next stage, which is whether the state prosecutor can charge the president and maybe issue an arrest warrant for the president. I'll be frank. I thought Trump was going to win this case when it first got filed. I did not think it would come out this way. But vote wasn't even close. I was actually surprised. I didn't think the court would allow a state to subpoena the president. I thought they would just allow immunity to, but what do I know? I think a lot of the jurisprudence, a lot of the cases in the last 4 years, I think come out the way they did because of Trump. I do think that I was surprised. Anyway, all right. Questions on the Vance case. We'll get to Mazars in a moment. No? All right. Who's next? Gavin, are you next?
Yes, sir.
Oh, look at that. You're at the top of the queue. Very good. All right. Gavin, who issued the subpoenas in the next case, Mazars?
So, yeah, it was the subpoenas to the same accounting firm, but this time it was congressional committees that issued the
Wait a minute. Hold on, Gavin. Let me just stop you. Are you telling me that the New York District Attorney, by total coincidence, requested the exact same information as these congressional committees? Just a total coincidence?
I don't believe much in coincidences.
No, sir. Do you think they were working together?
Yeah, there may have been some collaboration, or at least they both had the same goal in what they were doing.
All right, and what was their goal, Gavin?
To get the financials and tax returns of Trump, as well as his children and his family for like the last 10 years.
Yeah. I'll come back to you in a second, Gavin. That's very good. Let's just be candid here. They were working together. This was a collaboration. They had the exact same requests. I think it was almost verbatim. So this was like total collaboration, right? They were like, we don't care how we get these, whether it's the district attorney or the committee. See, I had originally thought it would go the other way around. When I first thought about this case, I thought the state would lose and Congress would win. That's how I originally thought it would go down. But then as it's developed, I actually realized it would be flipped. But so I always thought the Congress would win, not the state district attorney. In fact, I'd be more comfortable with Congress requesting this than the DA. So Congress is another branch of government, but that's why I'm here and Roberts is there. All right, Gavin. So why did the congressional committees request this information?
Well, they requested the information for part of their investigation.
And what were they investigating?
I mean, they were investigating. They wanted to investigate for legislative reform to see the impact of his financials on, to stop terrorism and stuff like. It was kind of a strained motivation. I mean,
wait, hold on, Gavin. We just had an impeachment last year, right?
Yes.
Where the president was accused of engaging in high crimes and misdemeanors. Was this request tied to the impeachment?
It does not specifically say so. It says it was ranging from money laundering and terrorism.
Money laundering
and U.S. elections. So yeah, in that regard, foreign involvement in U.S. elections, you could say it was.
No, but was this actually part of the impeachment inquiry?
No.
Okay, very good. So this is a common misconception about the case. I think most people simply assume that the House committees requested this information as part of the impeachment inquiry into President Trump. They didn't, and there's a very good reason why. The impeachment came to an end. It ended, was in February of last year. Had the committees tied these subpoenas to the impeachment inquiry, once the impeachment drew to a close, the subpoena would become moot. So that committees did not connect the subpoenas to the impeachment. Instead, they adopted, I think Gavin used the word strained. It's a good word. This sort of strained purpose, which was considering legislation. Hold on. Vikesh, you here?
Yes, sir. How are you?
Oh, well, thank you for asking. I appreciate that. What does that mean that the committees were considering this information for possible legislation? What just try to spell out what they were trying to do here.
Yeah, so I think this kind of goes back to what you mentioned earlier. A little bit, at least my take from it, is when they're writing potential legislation, you want to make sure it doesn't necessarily have a full benefit to the president. I think, like you said, like if they wanted the debt to be wiped, was it something that interests them moving forward? Was that kind of legislation that they would pass? Is there like that conflict of interest?
Well, let me ask a question a little more precisely, Vikesh. Why does the committee need a decade of the president's tax records to write legislation about the sitting president? In other words, if the concern is what are the president's conflicts, why do they need his records from 2015, 2005 when he was still like a reality star, whatever?
Yeah, I mean, I don't know why they exactly need it. I feel like that goes a little far back, but I mean, you can make an argument maybe he was setting himself up or aligning himself before the potential before the possibility of getting into office.
All right, Vikesh, let me ask you one more question if I can. What gives Congress the power to request information at all? Where in Article 1 is that?
No, it's not supremacy, that's Article 2. I'm not quite sure.
Is there any specific provision of the Constitution that authorizes Congress to request information?
I guess in the sense of an impeachment.
Oh, yeah, definitely for impeachment, right?
Mm-hmm. I guess it's only when they're investigating, but otherwise, under Article 1, I don't think there is.
Yeah, very good. Thank you, Vikesh. A few minutes ago, I asked someone, what is the source of the Constitution of the president's immunity? And the answer is there isn't any, right? There's no text that expressly gives Congress the power to be immune. What about congressional investigations, or what's often called congressional oversight? What text of the Constitution gives the president the power to investigate, to have oversight of the executive branch? And the short answer is there's no clear text. Right? There's no actual text that gives Congress the power. The court has said in various cases that Congress has a duty to have what they call eyes, right? To look around. And Congress should use every means in its power to figure out what's going on in this country, right? What areas warrant legislation, right? How can we best develop laws? And historically, that meant Congress could subpoena people to come testify before Congress, right? You always see these hearings, there's someone testifying with the bright lights on their face, right? What gives Congress the power to subpoena people? Sort of implied power, right? It's not really listed, but it's sort of understood. What about requesting documents? Well, yeah. Let's say Congress wants to legislate in the financial industry. Maybe Congress wants to request some documents from a bank discussing its transactions. You can do that. What about requesting information from the president? Right? Can the House Representative Committees request this information? Well, this was the first time that you ever had a request directly from the House committees to the president. President Trump once again argued that he had absolute immunity, right? That the House could not enforce a subpoena against him, right? They could not go to court because it violates the separation of powers. The House said, no, we can request whatever we want. And the courts have to enforce it. Right? Trump says, no. You need a very specific reason why you're requesting this information, and you cannot do it. Right? You need a very specific reason why you're requesting this information. Roberts, right? Does this opinion resolve this case? No. Not even close. Roberts does not agree with the House, which asserted an absolute power. Roberts does not agree with the president, who said they need a very specific reason to request these documents. Why? Well, if the House is right, there will be no limits. They can request any aspect of the president's records. And that could weaken the presidency. But he thinks the president's standard is too stringent, that maybe Congress can request information with less of a specific need. So the chief says that neither side really understands the correct balance of the separation of powers, so I will balance it myself. And he puts forward a 4-factor test. No, this is not torts, this is ConLaw. Lord help us. A 4-factor balancing test. Several special considerations. We don't even know which consideration matters the most. I hate balancing tests. I do. This is why I don't teach torts. I never got torts. It doesn't sit well with me. I like rules, not standards. This 4-factor test will just bedevil the government for decades. This was like the worst possible outcome. I would have much preferred he ruled that the House is right and just give the House his power. Because this test will just create conflict that will never be resolved. So there are 4 considerations. Let me walk you through these. First, court should carefully assess whether the asserted legislative purpose warrants the significant step of involving the president in his papers. What does this mean? Well, if Congress can get the information from somewhere else, it should. Right? If there are other sources for this information, Congress uses other sources. It's not clear that the tax returns are available anywhere else, so I'm not really sure which way this first factor cuts. Second, the subpoena should be no broader than necessary to support Congress's objectives. The subpoena has to be specific. In this case, the subpoena was not very specific. It requests, I think, a decade of records that were from even before the president was in office. I think they overshot. Maybe if they just requested the president's return from 2017, which he filed when he was president, that might have been a little bit neater. But they requested everything. They wanted to know the entire, decade of records. Okay, what's the third factor? The courts that enforce the subpoena should be attentive to the evidence offered by Congress. What's it mean to be attentive? I don't even know what this third factor means. It's, sort of fluff. The fourth one is actually where the work is being done. The court should assess the burdens imposed on the president by the subpoena. Now, why is this important? Because in our system of government, the president and the Congress are often at odds. And the Congress tries to bolster its own power. and the president tries to assert his power, this decision weakens the president and strengthens Congress, and allows Congress to put burdens on the executive branch. So the court should assess these burdens, because you have a rival political branch that might try to use subpoenas for its advantage, right? So even if the Congress can't impeach or remove the president, they can embarrass him politically by issuing subpoenas for perhaps embarrassing documents, shameful documents, things that will make the president look bad and could force him to resign, or that could force him to not assert his power. Or maybe they can blackmail the president, right? Or extort the president, saying, if you don't sign this bill, we will request documents that will embarrass you. By giving the Congress this advantage, Robert says, you give Congress an advantage in the political game, which they may not have had otherwise. Now, I told you this is a 4-factor test. Are these the only factors? Of course not. Other considerations may be pertinent as well. What are those? Who knows? One case in 200 years does not give enough experience for an exhaustive list. So we have 4 factors. There could be 7. Who knows? We just don't know. This test is a disaster. I dread the next time this is litigated. Trying to figure out these 4 factors is not going to be helpful. And this is not just of a Democratic Congress issuing a subpoena to a Republican president. Soon enough, you'll have a Republican Congress issuing a subpoena to a Democratic president, and all the rules will be reversed. Everything just flips around every 4 to 8 years. Whatever rules are established here, at least in theory, should control a Democratic president just the same. Okay, questions in the majority by the chief.
Are you going to rely on us to know those? You're not going to rely on us. You're the professor. Are you going to expect us to know those 4 factors?
Yeah, unfortunately, that's that.
And I have a question about the third one, because I wrote, Congress adequately identifies its aims and explains why the president's information will help shape possible legislation. I had like a requirement on Congress to explain more specifically why they are asking for that and what it's going to accomplish regarding future legislation.
That really, in my mind, blends in with the second one and really the first one. Right? I mean, really 1, 2, and 3 kind of all blend together. Really, the only factor that matters is 4. You see what I'm saying? Yeah, I mean, I see what 3 says, but, is it going to be really much different than 1, 2, and 3? They're all more or less the same. The one that matters is 4. And they're just asking, 1, 2, and 3 are about saying, has Congress really said why they need it? And number 4 says, is this need worth the burden?
I guess I pulled a Roberts because I found a way to make all 4 of them mean something different.
Oh, good for you. No, that's good. Maybe I'm being too cynical. I don't know. I'm. In other words, I think the evidence used to satisfy 1, 2, and 3 will be very similar. The same Congress say, we need this to do this, we need this to do this, and we can't do any other way. I think it's going to be very similar. But I think 4 is where all the action is going to be had. Like, how burdensome is this? And that's what the court's considering on remand, of how problematic would it be to the president to request information. Okay, thank you, though. There was a dissent. Once again, Justice Thomas dissented. He would have blocked the subpoena altogether. He was alone. Justice Alito, I think, agrees with Thomas, although it's not entirely clear. But Alito says the House has to do more. This is just so vague. You're investigating legislation. You don't need the president's tax return. This is just a political way of getting the president's returns. Douglas asked, what about the factors in Vance? I think the Vance case is a little bit easier. I think it's more of a bright line rule, in that the district attorney is allowed to subpoena the president even though he's present. I think it's not so much of a 4-factor balancing, because I think it has a little bit more teeth to it. Okay. Questions on the second case, Mazars? Oh, Lord help me. Well, let me try to summarize the best I can. These are hard cases to teach, and I don't envy you, and I don't mean that lightly, but it's hard to teach live issues because they're sort of emotional, and you think people walk into class generally with an opinion on these issues one way or another. Like, you don't care about whether President Roosevelt could fire the FTC commissioner in 1935. You really don't care. But this issue you probably do care about, either one way or the other, which makes it harder to sort of view objectively. I get that. It's just one of the rubs of teaching modern cases, which is why I try hard not to make this a current events class. I think it's very bad. Professors do it. I try not to. But at a minimum, we can synthesize the cases in one way. Vance gives the district attorneys a lot of power to subpoena information during the investigatory stage, even if it involves the president. And so long as there's no harassment going on of the president, the subpoena is valid. But I think Mazars cuts in the exact opposite direction. The House needs to be very specific with its request. They can't just give general requirements. And even if it's specific, I think you might have the president say it's too burdensome. So the Vance case gives power to the states. The Mazars case, I think, gives a limited power to Congress, but it's very constrained by this framework. So it's sort of this weird outcome where the separation of powers is sort of jumbled around, but in not a clear, cohesive fashion. All right. Questions on these three cases? And I started the minute poll for you to take a look at. Anything? Yes, Raymond, go ahead.
So, excuse me, if we were to see something, so let's say it's determined, you give us a question on the issuance to the subpoena by Congress. If somehow, we weigh out the balancing factors and it turns out that Congress's issuance of the subpoena is not valid under those factors, we'd say that the issuance violated the separation of powers. That's how we would conclude it, right?
Yeah, the subpoena's not valid. Exactly.
Okay, thank you.
Yep. All right, I'll be back here on 12:30. I hope to see you all soon, and good luck for the exam on Wednesday. Thank you.